Good to have you with us. Today, in a specific case related to the Delhi riots, the riots that took place in February 2020 and that led to massive destruction and loss of life. The Delhi High Court gave bail to 3 activists. These 3 activists, youngsters, part of the Pinjra group, 2 of them, have been in jail for over a year now. They were arrested under the Terror Act, the UAPA Act, and put behind bars in May 2020. Let me first tell you about these 3 activists. Asif Iqbal Tanha, accused to be a conspirator and instigator of the riots. The police calls him one of the masterminds who formed WhatsApp groups to manage the protests and decided to hold a chakka jam in northeast Delhi, mobilize women and children to stop police action, visited Muslim-dominated areas for campaigning. That's their case against him under the UAPA. Natasha Narwal, accused of instigating locals in Muslim-dominated areas, instigating women to protest against Citizenship Amendment Act and NRC by the government, the conspiracy to commit certain offences, conspiracy that led to the riots in northeast Delhi. Devangana Kalita, also similar charges, exactly the same as that for Natasha Narwal. And these 3 have been in jail since May 2020. And you know, during the times of a pandemic, many others were actually let out of jail owing to the pandemic conditions. But these 3 didn't even get that chance because the charge against them was under the Terror Act, the Anti-Terror Act. And so those decisions didn't apply to them. But here is what the High Court had to say today when it granted bail. It came down heavily on the state and the police under the state. The High Court said that there is a difference between constitutionally guaranteed right to protest. It's a constitutional right that you and I have, the right to protest, which is extremely different from any terrorist activity. The court said UAPA cannot casually be applied to criminal acts. The court went on to observe that it looks like in the state's mind, the line between right to protest and terrorist activity seems blurred. Let this sink in, the court observed, about how the state is viewing people protesting against laws in this country. And if this mindset, this is what the court said, if this mindset gains traction, it would be a sad day for democracy. Specific to the charge sheet filed by the Delhi police under the UAPA section, the court observed that there is complete lack of specific factual allegations other than those spun by grandiloquence. Now, essentially saying that this grandiloquence that is mentioned in these claims in the charge sheet is not backed by facts that this was indeed a terrorist activity. We have repeatedly said this over the last 1.5 years since these protests began. And then they got linked to the riots. And then the crackdown on the protesters and these activists. That the right to protest isn't the same as sedition, war against the nation, or a terror activity. It is our fundamental right. For the court to then turn around and today say that nothing in your charge sheet so far, prima facie, nothing in your charge sheet points to a terrorist activity, and thereby the UAPA rules for bail will not apply, and we will consider this as a normal case and grant bail. This only validates what we have been repeatedly raising here and discussing. Over the next 40 minutes, I will also give you various examples where Delhi police has been pulled up by various courts in their investigation into the Delhi riots. Because at every step, it looks as if the Delhi police had only one agenda: to go after certain people, put them behind bars, and not really to bring the true culprits to justice or to justice to the victims of these riots. I say good evening to Neha Shalini Dua, spokesperson for the BJP, Harsh Mandar, social activist and former IS officer, Deshratan Nigam, advocate with the Supreme Court, Dr. Vikram Singh, former DGP of Uttar Pradesh. But I first want to start off with Mr. Kailash Vasudev, senior advocate with the Supreme Court. Mr. Vasudev, for the court to look at the charge sheet and say, well, I don't know where is the factual part for the UAPA, and then to make comments to differentiate between a right to protest and terror activity. Would you say that this isn't just one instance, but this is now becoming a big concern that we are seeing in several other parts?
Evening. You see, if you look at the rights, the freedom rights which are there, and how they have gone about right from Ramesh Thapar in 1950 till date, the courts have always been alive to the fact that you cannot permit rights to come into the picture or be trampled by obtuse actions of governance. If you look at two recent judgments, both of some significance, one is Vinod Dua. In Vinod Dua's case, he was charged for sedition, and the Supreme Court quashed the proceedings which were initiated in Himachal Pradesh. He's a resident of Delhi. Today, the Supreme Court has granted bail to those persons who were arrested on similar charges, including the UAPA. We have to accept the fact that these kind of actions in trying to bring people to book do not augur well for a democracy. In a democracy, the right of protest, the right to say your views should be accepted and be given respect. We have a situation now, Himachal is ruled, it has a government of a particular party. UP has a similar situation. Today in Delhi, it's a divided house between the center and a newly elected government of the state. So wherever you are going to use your party philosophy for the purposes of perpetrating a particular action, the repentance will eventually be of the government, of the police, and of the authorities, because the courts are not going to accept this, as you are seeing of late. Even as far back as 2018, the right of freedom included the right of independence. There's a whole lot of judgment in Puttaswamy's case. So therefore, the present action by the court is absolutely correct. We abide by it. We must accept it in the correct perspective in which it has been delivered. Justice Mridul has given, and Justice Bambani have given very, very good views on freedom of speech. Justice Lalit of the Supreme Court has done the same thing. So therefore, it is time that we woke up pushing brute force for the purposes of quelling rights is not going to last. We have to stop this.
And you know, Mr. Harsh Mandar, one very interesting point was of how you cannot use this law casually. The anti-terror law is meant for a specific purpose, for those genuinely looking to carry out a terror attack or wage a war against the country. Now, how do we ensure that this misuse or abuse stops? Because otherwise, in every instance, we'll have to wait for 12 months, 14 months before somebody gets relief.
Actually, most important role to defend us from this misuse of the law is of the courts, of the higher courts. And today is an important day, in the journey of our republic, I think, because after a long time, the higher courts have actually intervened and said something that is obvious to most impartial observers, that people protesting, using their right to dissent against government policy and law are not terrorists. And the idea that there's a conspiracy, my name has been incidentally mentioned in a number of charge sheets, in affidavits of the Delhi police to the Supreme Court and the High Court, claiming that we are part of some insurrection, violent insurrection to overthrow the government and and cause all kinds of terrorist activities. We were basically opposed to a law which we felt went against the constitution and its guarantees of equal citizenship to people of every faith. Uh, we might be right, we might be wrong, but we have a right to put forward our view and to protest. What this government has been doing consistently, and this happened with Bhima Koregaon, 3 years have passed very recently, and people are there indefinitely. You're keeping them behind bars. Many very respected people here in Delhi riots. We have a lot of very fine young people who have been put behind bars, and there is no opportunity for them to actually uh, prove their innocence. And you can indefinitely keep them there. If the Delhi police is so confident about its case here, they should simply put forward their evidence. And the evidence that they've put forward so far, the High Court has said, I mean, there just is no substantial evidence at all, prima facie, to detain them. 1 year of young people's lives have gone. Many more are there for longer periods. We've also seen Bhima Koregaon. So there are two quick things that I wanted to say. One is that I think Parliament and the legislature need to be questioned about the passage of laws which allow this kind of misuse of elementary due process in order to punish people by process. I wrote recently about this. The punishment is really in the process. At the end of all of this, you'll declare them innocent, but they, years of their life. Natasha lost her father and could not be by his side because the courts just didn't give her bail. There's nothing that can heal that loss, and that is for somebody whose guilt has not even been proved. And so I think that firstly we shouldn't have such laws, and secondly, the use and the misuse of these extraordinary laws to crush legitimate dissenters, as the court has said today, against government policy is something that is, it threatens our entire democratic framework.
Yeah.
And we all need to stand together in defense of it.
Yeah, absolutely. In fact, let me also say good evening to Geeta Pal, family member of Natasha Narwal. And Geeta, what Harsh was saying, we all know that Natasha's father, tried really hard and for the past 1 year to, get her out, to get that relief. अगर पर आज वो होते तो उनको कितना अच्छा लगता है ये जान के कि जिस चीज़ के लिए वो लड़ रहे थे, अपनी बेटी के लिए, उसको छुड़ाने के लिए, उसका नाम क्लियर करने के लिए, वो आज कोर्ट ने दे दिया.
हेलो, गुड इवनिंग. मैं नताशा की बुआ गीता पाल. नताशा 13 साल की थी जब उसकी मदर की डेथ हुई. तो मेरे ब्रदर ने ही उसकी परवरिश की, और मेरे ब्रदर शुरू से ही, डॉक्टर महावीर नारवाल, शुरू से ही सोशल एक्टिविस्ट रहे हैं. वो भी स्टूडेंट्स लाइफ में वो भी जेल गए, लेकिन उन्होंने वो बहुत ही ब्रिलियंट स्टूडेंट थे और थ्रू आउट वो गोल्ड मेडलिस्ट रहे. और इन सारी चीजों के बावजूद भी पुलिस उनके पीछे रहती थी, तो भी उन्होंने जो है अपना गोल्ड मेडल को बरकरार रखा. और जहां भी असमानता की बात थी वो खड़े थे, और उनकी परवरिश के कारण ही नताशा ऐसी बनी. और हमें नताशा को बनाने में उनका बहुत बड़ा रोल था. नताशा तो बहुत आगे निकल गई. और नताशा जब उसकी जेल हुई तो हमें इस बात का दुख नहीं था कि वो जेल में चली गई. इस बात का दुख था कि वो बेकसूर है. अगर वो कसूर करके चली गई होती तो हम शायद इतना दुख नहीं लगता हमें. और एक फादर को ये पता है कि वो बेकसूर है और वो जेल में है, और वो उनके लिए बार-बार पेपर साइन करते हैं, तैयार करते हैं, ले जाते हैं. उनको ड्राइविंग में प्रॉब्लम है, उनको आने जाने में वो बहुत कश्मकश में थे, लेकिन उनको भरोसा था कि उनकी बेटी ने कुछ गलत नहीं किया है। और वो कहते थे कि मेरी जहाँ अन्याय होगा वहाँ मेरी बेटी साथ खड़ी होगी, और मुझे मेरी बेटी पे गर्व है और हमें भी अपनी बेटी पे प्राउड है। हम उसके साथ खड़े रहे पूरी 1 साल तक, उसको हिम्मत देते रहे कि तुमने अगर कोई कसूर नहीं किया है, तुम बिल्कुल अपने कॉन्स्टिट्यूशन के लिए अपने राइट्स के लिए खड़े हो, तो तुम बिल्कुल ठीक हो और तुम्हें कितनी भी टाइम लग जाए तो कोई अफ़सोस की बात नहीं है, तुम पीछे नहीं हटना, हम तुम्हारे साथ हैं। लेकिन जो ब्रदर की डेथ हुई और उस दौरान जो है हम लोग सॉरी जिस ट्रॉमा में रहे, उसको तो बयान ही नहीं किया जा सकता। अगर नताशा जेल में नहीं होती, तो वो नहीं जाते, क्योंकि वो बिना केयर के चले गए। घर में मेड भी पॉजिटिव हो गई, भाई भी पॉजिटिव हो गया, उनको कोई केयर करने वाला नहीं था। इस बात का बड़ा अफ़सोस रहा हमें कि नताशा होती, तो उनके साथ ऐसा नहीं होता। फिर भी जो भी हुआ, लेकिन नताशा को जब इंटरिम रिलीफ मिला 21 दिन का, 3 वीक्स का, और भाई साहब पता लगा था कि वो जा चुके हैं, उसको पता लगा। लेकिन बेल के लिए अप्लाई किया हुआ था, टाइमली नहीं मिली। इस बात का बहुत अफ़सोस रहा कि वो मिल नहीं पाए। अगर वो मिल पाते, तो उनको एक मन में भरोसा होता, या बेटी को देख पाते, या बेटी को भी अपने बाप से मिल पाती। तो उसके लिए हमें बहुत मतलब ये बहुत पेनफुल था। और जिस तरीके से जैसे बेल हुई, उसकी इंटरिम रिलीफ मिला, तो वो जा चुके थे। लेकिन ये पता लगा कि 11 बजे उसको बेल मिल जाएगी, 11 बजे तक, और जो भी फॉर्मेलिटीज़ हैं उसको 12-1 बज जाएगा। और डेड बॉडी मॉर्चरी में थी, और हम लोग नताशा को लेने जेल पहुँचे, और हमें 8 घंटे तक इंतज़ार करना पड़ा कि वो जेल से बाहर निकले, बाहर निकले, बाहर निकले। और हमें ये बताया गया था कि नहीं, स्पेशल केस में जो है वो जल्दी उसको रिहा कर देंगे, जल्दी वो आ जाएगी, मैक्सिमम 2 बजे तक। फिर हमें बताया गया 5 बजे तक आ जाएगी। फिर हमें बताया गया कि नहीं, 9 बजे से पहले नहीं आएगी। और उधर आकाश जो नताशा का भाई है, वो कोविड में था और वो अकेला ही था, और क्योंकि कोई लोग मिल नहीं सकते थे, वो बार-बार फ़ोन कर रहा था कि मेरी बहन क्यों नहीं आई अभी? क्या ऐसी क्या वैसा बात हो गई है? हमें बताओ, मुझे बताओ कि वो बाहर क्यों नहीं आ रही है? और वो हम लोग उसको लेके 11 बजे रात को पहुँचे, तो क्रीमेट भी नहीं कर पाए, और नेक्स्ट डे फ्यूनरल पायर को क्लेम करने के लिए कोई नहीं था, तो नताशा को ही करना पड़ा। तो ये जो कॉस्ट उसने दी है, या पूरी फैमिली को झेलना पड़ा है, ये ट्रॉमा, पेन, उसको नहीं बताया जा सकता, उसको बयान नहीं किया जा सकता। और जो
जिस समय गीता
बाद
जी,
में
आपके जिस समय महावीर जी जिंदा थे और नताशा को फ्री करने के लिए जब इधर से उधर वो भाग रहे थे, वो कैसे इस दर्द के साथ डील करते थे कि मतलब कोविड के समय, पैंडेमिक के समय, 1 साल से वो जब जेल में थी, ना मिल पाते थे, तो वो उस चीज़ को कैसे हैंडल कर पाते थे?
मुश्किल था उनके लिए बहुत। अ, और उनको लास्ट में जो उनकी वीसी होने वाली थी, जिसमें नताशा के साथ उनकी बात होने वाली थी, वो भी नहीं हो पाई थी किसी कारण वजह से। और उनको ये अफ़सोस रहा वो कि हमें मुझसे एक बार बात हो जाए उसकी, और वो नहीं हो पाई, वो उनको अफ़सोस रहा। और बड़े ही मुश्किल का दौर था वो उनके लिए। और वैसे वो बाहर से मतलब दिखते थे कि नहीं, मैं ऐसी कोई बात नहीं है, लेकिन अंदर से उनको बहुत इस बात की घुटन थी, अंदर से बहुत पेन था कि मेरी बेटी जो है वो बेकसूर है और वो जेल में है।
जी, जी, जो जो आपको और आपकी फैमिली को जो कॉस्ट इसकी सहनी पड़ी और झेलनी पड़ी, मेरी बस यही उम्मीद है कि इसके बाद, और जो कोर्ट ने आज बोला, ऐसा और ना हो किसी के साथ। जो आपका लॉस है उसको तो अब नहीं बदला जा सकता, बट एटलीस्ट इससे आगे के लिए हम कुछ सीख पाएँ, यही हमारी उम्मीद है सिस्टम से भी और जुडिशरी से भी।
हाई कोर्ट का जो डिसीजन है, दिल्ली हाई कोर्ट का, उसका स्वागत करते हैं। वो बहुत ही ब्यूटीफुल डिसीजन है। उसकी मैं एक लाइन पढ़ रही थी, मैं आप कहें तो आपने कह
जी,
के सुना
जी।
दूं। कि वो बहुत ही सही है। असहमति की आवाज को दबाने की जल्दबाजी में सरकार ने विरोध करने के संवैधानिक अधिकार और आतंकवादी गतिविधियों के अंतर को खत्म सा कर दिया है। अगर यह मानसिकता जोर पकड़ती है तो यह लोकतंत्र के लिए दुखद दिन होगा। ये इतना मतलब साफ साफ और प्रामा फेसी जो उन्होंने कहा है कि उनके खिलाफ कुछ है ही नहीं, ऐसा कुछ
जी
दिखता ही नहीं है कि वो इस तरह की खतरनाक चीजों में इन्वॉल्व होंगी। तो ये इस बात का है अफसोस है।
जी बिल्कुल सही गीता पाल, थैंक यू, आपने हमें समय दिया और हमसे आज बात करी। मैं आपको ज़्यादा देर नहीं रोकना चाहूँगी, पर अगर आप रहना चाहें और सुनना चाहें जो जो बाकी लोग बोल रहे हैं, यू आर मोर देन वेलकम। आई
हाँ,
वांट टू
सुन
टेक दिस टू
मैं सुन
नेहा शालिनी। नेहा शालिनी, you heard the cost that a family had to pay, the pain that they had to go through. ये सरकार को इतना डर क्यों लगता है स्टूडेंट्स से? दिशा रवि को तोड़ दिया, वो कोर्ट में रोने लगी, उसके पीछे भागे सेडिशन को लेके। यहाँ नताशा और बाकियों के पीछे टेरर एक्ट को लेके। Why are you so scared of students?
No, Tanvi, we are not scared from the students. India is a democratic country and we believe in democracy. But in democracy, you have the right to protest. You have the right to raise voice against the government or any individual. But if your voice is, I'm going to say, is, your voice, if your speech made communal rights, then it's not acceptable. If your hatred speeches killed innocent people, then it's not acceptable. If your wrong narrative killed, injured 200 people, that it's not acceptable. So we accept these things that you are against CAA bill, which was passed by the parliament. It's your fundamental right. You have to raise your voice. But all these things, wrong narrative, wrong hatred speeches, so they killed by their speeches, by their wrong narratives.
Neha Shalini, I don't know if you've
50
read the order. Would you want me to send you a copy of the operative part? एक part तो अभी गीता जी ने पढ़ के सुनाया, and I read out some of the other operative parts as well. The entire charge sheet is a sham in the name of UAPA Act. There isn't anything to provide evidence that this was a terrorist activity. That's essentially what the court has said it. I am not saying it. The court says that the state, which is you, the government, seems anxious about dissent in this country, and you cannot make out the difference between right to protest and a terrorist activity. Are you still going on and on about what you would have told to me a year and a half ago?
No. Actually, few people said the wrong narrative that the CAA bill is totally against the Muslims. And government took Muslims to the detention centers and there they would kill them. So
Is that something that you call a terrorist activity? Is that a terrorist activity? That you put somebody in jail for 1 year, don't allow them to go and meet their ailing father, don't even give them relief in the middle of a pandemic, when in every part of this country from jail, people are being released and giving relief, not these students.
But Tanvi, by the wrong narrative, you killed 50 people and 200 injured.
And what about the BJP leaders who were giving goli maro type sloganeering? What about the BJP leaders who were threatening the police officials on ground saying तुम कुछ करो नहीं तो हम करेंगे? What about those who went and instigated? उनके साथ तो कुछ नहीं हुआ?
उनके साथ देखिए जो आप बात कह रहे हैं और इसमें बहुत डिफरेंस है।
नहीं है, ये उसी समय की बात है।
नहीं, आप ये देखो तन्वी, एक कॉम्युनल वो किया जा रहा था, एजेंडा सेट करा जा रहा था जामिया में बैठ के कि हाँ हम ऐसे करेंगे और मुस्लिम्स के ये अगेंस्ट है। सीए में कहाँ मुस्लिम्स के अगेंस्ट है? टेल मी, कहाँ ऐसा लॉ है जहाँ सीए में ये लिखा है कि यहाँ से आपको यू सेंड टू द डिटेंशन सेंटर एंड देन दे वुड किल यू। मतलब वहां उनको मुस्लिम्स को ले जाया जाएगा और उनको मार दिया जाएगा, खत्म कर दिया जाएगा। और इसके लिए दे सेट द नैरेटिव दैट मोदी जी मेड द हिंदू राष्ट्र। तो बेसिकली ऑल बेसलेस न्यूज की वजह से ही ये एक्ट, ठीक है हम मानते हैं टेररिस्ट एक्ट नहीं है,
complete lack of specific factual allegations other than those spun by grandiloquence. Mr. Deshrattan Nigam, this is what the court has said. Now, Who should we
But
blame?
if,
That 1 minute, please.
if you
Who should
spread
we
the
blame?
hatred,
Should we
which
blame the Delhi police?
and
Because 1 minute,
your
Neha. 1 minute,
hatred, which is
please.
more than
Let me
30
speak.
people killed, is
I
it
am
right
going to
with
the
me?
other
अब
panelist.
आप वैसे
Let me
बोलेंगे,
speak.
right?
I am only quoting what the courts have said. From Patiala House Court to the Delhi High Court. The Delhi police has been slammed for improper probe. The Delhi police ended up compromising this identity of witnesses by attaching their names and addresses and personal details as part of the charge sheet and then said, oops, sorry, galti ho gayi. The Delhi police has been questioned on the use of Anti-Terror Act and the Sedition Act. The Delhi police has also been told by the court that your entire investigation seems to be targeting only one camp and not the other. Mr. Nigam, how many more times do we need the courts to tell us that the Delhi police has made a mess of the riots investigation?
Tanvi, let me point out few things. Before we reach any conclusion, we must know these are orders in bail, not a decision in a final decision or case proving somebody guilty or not guilty. That will be done after trial. Any observation made by the court in bail does not affect trial. It has zero value for the trial judge. The courts may say anything in bail, but that does not impact the trial. That goes on an independent footing. And more so, the court, the present order that you're talking about talks of only prima facie. The court has not got deep into it, nor it has given any conclusive finding. So to say that the person has been proven not guilty is something, is a fallacy and should not be propagated in this program by anybody. And there are certain very important issues. If you have to see what terrorist act is, please read section 15 of UAPA, and what happened during riots is specifically covered in that. So entire issue, evidence will have to be looked in trial. The bail court cannot even go into it. Even if it goes into it and makes a comment, it has zero relevance for the trial. So let us be very, very clear. This is only a bail. Bail means you have been set free and you have to abide by conditions and participate in the trial of your case.
Fair
And
enough, Mr.
ultimately,
Nigam, but fair enough, Mr. Nigam, you are right.
Trial court will decide you
Yeah.
are guilty or not.
Fair enough, you are right. But the court did say, is it not correct, that since we are of the view that no offence under sections 15, 17 or 18 of the UAPA is made out against the appellant on a prima facie appreciation of the charge sheet and the material collected and cited by the prosecution, the additional limitations and restrictions of grant of bail under UAPA do not apply.
Let me answer that. This is an irrelevant observation by the court because everything is prima facie out here. The court has not gone deep into evidence to look into what kind of an evidence is available. And in bail, you don't appreciate evidence. That is what the law is. And therefore, bail is given on totally different consideration, not on those evidences that you have to see. So these observations are immaterial and will not impact. Let me tell you, that is what the law is. And I think any lawyer will tell you worth a salt that these observations will not make any difference to a trial judge.
Okay, let me bring in Dr. Vikram Singh. Dr. Vikram Singh, to the point that I was making earlier, from the Patiala court to the Delhi High Court, repeatedly since August last year, questions have been raised in the way the investigation. There is no denying the fact, Mr. Singh, that riots took place. There is no denying the fact that people were killed, that houses were burnt, and a crime has taken place. But there is definitely a concern on the way this investigation has proceeded.
Tanvi, make no mistake about it, that this is one of the most serious riots that Delhi has seen post-independence. The timing and the manner in which Ankit Sharma was brutally murdered, well, it has left all of us shell-shocked. But I am very disappointed in the manner in which this investigation was carried out. This was a prime investigation, and they should have put their best foot forward, and the best investigators should have been entrusted with the case to make it an absolute dead, open and shut and infallible case. And if the prime accused are let out on bail, whatever may be the reasons, as Mr. Deshratan Nigam, who is a very seasoned lawyer, says, it was due to perverse observation. I am in no position. But the fact of the matter is, when any such things happen, there are consequences for the investigators and for the prosecutors. And there is a procedure of departmental action. When such people are let out on bail, there should be consequences for the prosecutors. What were they doing? They were in the Midsummer Night's Dream that the so-called key accused were let out on bail, and they did nothing whatsoever, and they're now mulling over the judgment. I am very disappointed. If they took pains to put them behind bars, they jolly well should have run the extra mile to ensure that the adequate and the proper evidence was brought before the court. And the best prosecutors, even if you had to hire somebody as important as Mr. Nigam or Mr. Vasudev, they should have been hired to put the case of the Delhi police before the court. But cutting a sorry figure in front of the public after 14 months is just not acceptable. This was the case and they were the accused. And I can tell you from my experience, 60% of such cases do end up in acquittals and bails at the end of the day. They do end up, but it is not without the consequences to the investigators and to the prosecutors. If it does happen, I think the investigation itself is supposed to be as sacred and the integrity of the investigation should be as of the highest order as that of the court proceedings. It cannot be that some whimsical knee-jerk sad sack is interested with the investigation. He messes up with the evidence and produces or chooses to appear and chooses to go underground during the court proceedings. It does not happen that way. The entire might of the prosecution and the investigation comes up before the court so that there is no lacuna left. And as they say, that every shred of evidence is produced before the honorable judges so that there is no element of doubt. But I'm sure this was not done. And what has happened, well, it is a matter of debate and departmental action against the prosecutors and the investigators. Tanvi.
You know, I want to point out one other aspect. Mr. Kailash Vasudev, maybe you can come in on this. When it came to the specific bail for Asif Iqbal Tanha, the court also said, should this case, court wait till right to speedy trial is fully negated. There was this whole back and forth that happened between the prosecution side and the court on, the charges and the evidence and the, witnesses that have to be cross-examined. And the court said, well, if you have 700 witnesses, we're not going to wait to hear all of them before deciding on bail, when prima facie I can't even see what is there relevant to the terrorist act. Now, how do we resolve such cases? These were 3 high-profile cases that came to light, but there will be many, many more in which people may still be in jail.
See, look at it this way. Bail is an interim proceeding where you're enlarged to go out. But in the bail proceedings, the judges make observations, prima facie, saying that this is the situation. Mr. Nigam is right, and so is Dr. Vikram saying. What is troublesome is, normally in bail cases, the court considers the overall circumstance on the basis of what it sees as a perspective, whether to grant or reject bail. There are 3 cardinal principles in bail. Man will be available for the trial. He won't abscond. He won't tamper with the proceedings. And he won't do anything which would be extrajudicial. These are the essential cardinal tests. When a court makes such serious observations during a bail, it is a matter where prosecution should wake up. We can frame charges, we can incarcerate a person, we can keep them in custody for as long as we want. It's a part of the government process. But when you unleash a fury in a circumstance where there is a dissent, the riots took place, people died, officers of government were killed, IB officers were killed. There were all sorts of situations which were horrendous to accept, possibly the worst riots Delhi has seen for a long time. But then, if you're going to make out a case, then you should make out a case where these people are not released on bail.
True.
I'm reasonably sure that this order will be challenged in the Supreme Court. We'll see the consequences thereof. But the worrisome element today is this. In the recent past, as I mentioned in the very beginning, Vinod Dua's case is an example. This is an example of granting bail. Vinod Dua is quashing. 124A proceedings were quashed. Sedition charges were made when the Supreme Court has taken exception. The approach today is keep the person in jail if you can't use the detention acts.
True.
Don't let them come out on bail. Let the trial linger. Now 300 witnesses, 500 witnesses, 700 witnesses. I mean, please understand, it'll be an unending situation. These are students. They might have done something wrong, yes. They participated in the democratic principle. They might have been sitting in an area which became violent. But are you going to destroy their careers for this? Is this governance? Look at the flip side. If the judiciary had not stood up today, this girl who could not meet her father on the deathbed would never see happiness for the rest of her life. You will create a terrorist out of her as you go along. The system is meant for the purposes of punishing those who are guilty. It is not meant for the purposes of creating criminals out of those who are not criminals. Our criminal justice system is being used for that. I mean, we have had debates galore on your particular channel. We have judgments of all sorts of. I'll give you another example, which is now getting to be very troublesome. Lakshadweep has been in the press. This particular journalist raised objections to certain actions of the now appointed administrator. You've locked her up under the UAPA. You've locked her up under sedition. Harish, all that she's saying is this has been a tradition we've had in our island for thousands of years. Please don't destroy it. Please don't sell Amul milk. We want to sell a local dairy produce. Is this a ground to lock up a person? I'm raising this as an aside because the abuse is now becoming apparent. Everybody will have a point of view. You're justified. That's a democracy. But don't use your fury to quell democracy. It is a message which people will not accept. Brute force has never been an answer. The emergency led to a totally new democratic pattern in our system. We became more fundamentally aware of our fundamentals.
Yes.
Today, we are coming down to a situation where, please understand one very important facet, and this is a message to all of us. Whether you are a tenure holder, whether you are a judge, whether you are in service, whether you are a lawyer, whether you are anybody, whether you're a politician in the Lok Sabha, you're a politician in the Rajya Sabha, in the bicameral houses, you're a governor, you have a tenure. You are not permanent. History will judge you. That test of history, do not make yourself comparable to a Machiavelli. Don't do that. The democratic systems in our country have to be protected and have to be moved. You want to prosecute? Prosecute correctly. You are amending laws. We had a discussion the other day on the Epidemic Act. Summary proceedings for those who stop doctors, who stop health workers. How many prosecutions have we had? 7. So therefore, what I'm saying is, please exercise your power as government. But when you exercise your power in government, don't abuse it. This observation by the High Court, although in bail, and Mr. Nigam is right, it's interim, it has an impact on the average man. It tells you where governance is failing. I am not on the law just now. The judgments of the courts are telling today, they're screaming for justice. Allahabad High Court orders with regard to the interfaith marriages. The orders of the Bombay High Court of late, the observations of the Madras High Court, Election Commission is not doing its job. I mean, please, we're a democracy. Let us maintain a system where democracy prevails. Let not brute force, let not a fury of abuse destroy the substratum of this wonderful country and our wonderful people.
Mr. Nigam,
We have
would
to
you like
wake
to
up.
come in here? Yes.
Yes, I would. See, Mr. Vasudev has raised 2 issues. One, which I agree, is about judicial reforms, and nobody should be incarcerated, during the trial for time immemorial. And that judicial process, the courts have also been improving upon, and there is a scope of improvement, further improvement also. Now, so far as this case is concerned, nobody, and let me tell you, nobody at this stage can say where the process has been used or misused. It is only after when the final judgment comes and finally goes to the court. So to say that these people are innocent or not innocent and the process have been abused here, I think that would be a fallacy. And so let us wait for the judgment, and finally, when all the evidence is appreciated, and finally, ultimately, the Supreme Court upholds it or rejects that judgment is a separate thing. Only then it will be conclusive. So today, to say that somebody has been, name has been cleared, that has not taken place. So these people, as of now, under the UAPA, please remember, they are guilty till proven innocent. Read section 38, subsection 1.
Right.
The law has
the owner
changed.
shifts.
So the ownership, so they are guilty
Yes.
till proven innocent. So that's a difference in the IPC and this particular law. So I am not going to give a clean sheet or otherwise at this stage. Or
But let me, you're right. And of course, this is at the bail stage by a high court and not the trial. You've pointed it out. But I also want to point out that the Delhi High Court, while granting bail to another set of accused in May, said that the prosecution's assertions prima facie brings its case under cloud. Identification of the accused before trial court and high court is at variance. Petitioner cannot be in jail for an indefinite period of time. The Karkaduma District Court in April 2021, in another case linked to the Delhi riot, said investigating agency evidently found to be on the wrong side of the law. Complete lack of supervision of investigations by senior police officers. All is not over yet, and even if officers look into the matter now and take remedial measures, justice could be given to the victims. Patiala House Court in May 2020. Case diary reveals disturbing facts. Probe seems to be targeted towards one end, and there is no update on investigation on the rival faction. The court is reminding the Delhi police that, listen, there were two sides in a riot, and you've not even looked at the other side. The Delhi High Court, talking about Delhi police, again in July 2020. Unwarranted allegations against Pinjra Tod activists. Agency leaked certain evidence to the media. And all of these instances, Mr. Harsh Mandar, are linked to the Delhi riots case. I am not even right now extending it to a Vinod Dua sedition case or a Disha Ravi sedition case and many other instances that Mr. Kailash Vasudev was referring to where similar observations have been made. But isn't there a concerning trend that sections and laws are being used to simply put people behind bars and then find ways of delaying the entire procedure so that they just stay behind bars for a longer period of time and the narrative gets built?
May I come in?
No,
I'm coming to you next, Neha.
And with the words that very eloquently that Mr. Vasudev spoke of. See, it is true that UAPA, you're guilty until proved innocent. But does that mean that we, with evidence that the High Court says prima facie is so flimsy, are you going to take away people's liberty indefinitely? Or is that something that we need to say should not be permitted any longer? As far as the Delhi riots are concerned, the argument is that there was a conspiracy behind it by people involved in the anti-CAA protests. There's no doubt that a much larger loss of life was of the Muslim community, much larger loss of property, religious purses. Are we saying that the Muslim community made a conspiracy in order to have themselves killed? We are talking nothing about, I'm talking about hate speeches. There were open hate speeches right through the Delhi elections at the highest levels of government. What happened to any of them? I myself went to the High Court and said, what about these hate speeches? Why are we not taking action against them? The Delhi police replied that there will be an appropriate time for it. All these months have passed. That appropriate time hasn't come. There is such open, bias. There's video evidence of the role of the police in, abetting the violence. No action has been taken. I think that any sort of independent citizen is able to see that this is really the misuse of a law to silence voices. You were talking about a false narrative. It's not a false. Who created the false narrative? Who created the fear among the Indian Muslims? Please remember that it was the Home Minister of this country who said, please understand the chronology. First, we will bring CAA, then we will bring NRC, etc. And we have the whole experience of what happened in Assam. So it is not an unfounded fear. It was a fear that was fostered actively by the statements of the Home Minister, no less. And therefore, if citizens, the thing to do was to reassure them and not to criminalize them.
Yes. You find other ways of convincing people and giving them assurances. Last 30 seconds to Neha. Go ahead, please.
Yeah. Tanvi, actually, I said Miss Natasha and her colleague, they spread the hatred speeches. They said the bill is against Muslim. They abolished their citizenship in India. Government took Muslims to detention center and then they would kill them. CAA is basically to make Hindu Rashtra. And one more thing. These all statements done by Miss Natasha and her fellow workers. So when Delhi police heard that news that some people, the group of few people are are sitting are making are trying to make communal riots in Delhi, so they against the CA bill, then police went there.
No,
But when
Neha
police
Shalini,
entered in the
let me
temple,
just tell you very quickly what the court observed on it, that if you say you created WhatsApp groups, if you say you even went to these areas and held rallies and spoke up, these are all ways and signs of how you organize a protest. To say this is a terrorist activity is a completely different thing. Please remember, right now we are only talking about the terrorist charge under the UAPA. Whatever else you believe, by questioning the CAA, if you say believe that people become terrorists in this country, I think you are highly mistaken. I'm sorry, but I'm completely out of time. I will have to wrap up at this point. I just want to also update our viewers as Geeta Palji is here and we heard her. Natasha is yet to be released from jail, and the final paperwork in the court proceedings will only take place tomorrow afternoon. We don't know if in the interim the government decides to challenge this order and go to a higher court. Quite possible that they have the opportunity to do this. But imagine this, viewers, to use such tough laws like the UAPA and in other cases the sedition law which actually dates from the Britishers' era. That's what they used to quell dissent. To have court after court after court say that your actions show that you are scared of dissent, you're trying to silence dissent, that you're anxious about dissent, that you're now blurring lines between what is a fundamental right and what is a terrorist activity. This shows that there is a larger trend. Whether Natasha will finally be convicted or acquitted is perhaps something we will only know years from here on, because that's how long it takes for cases like this to go on in our country to come to a culmination point. But was it fair for her to be in jail for a year over a terrorism charge because she was part of the anti-CAA protests in the weeks before the riots took place? Think about it. Thank you for joining us.